Well, hello there. Let's talk about the case of Feist versus Rural Telephone. Meet Rural Telephone Service Company. A small rural telephone company that provides telephone services and an annual telephone directory, including white and yellow pages, to communities of northwest Kansas. Now meet Feist Publications, a publishing company responsible for publishing telephone directories for a much larger regional area of northwest Kansas. Feist develops their own yellow pages, but since they are not a telephone company with access to subscriber info, they must collect white pages from local telephone companies to be included in their regional phone books. Feist approached the 11 telephone companies operating in northwest Kansas and offered to pay for the right to use their white pages listings. Of the 11 telephone companies who were asked by Feist, only Rural refused to license its listings. Rural knew that this created a problem for Feist, as omitting these listings would have left a gaping hole in its area-wide directory, rendering it less attractive to potential Yellow Pages advertisers. Since they were unable to license Rural's white pages listings, Feist went ahead and used them without Rural's consent. Once Rural found out, they sued for copyright infringement in the District Court of the District of Kansas. Rural took the position that Feist, in efforts to compile its own directory, could not use the information contained in Rural's white pages, asserting that Feist's employees were obliged to travel door to door or conduct a telephone survey to discover the same information for themselves. Feist responded that such efforts were economically impractical and in any event unnecessary because the information copied was beyond the scope of copyright protection. The Kansas District Court granted summary judgment to Rural in its copyright infringement suit, holding that telephone directories are copyrightable. In 1990, this ruling was affirmed by the U.S. Court of Appeals. For a work to be considered copyrightable, it must meet 3 requirements. First, the work of authorship requirement. Second, the originality requirement. And third, the fixation requirement. The first element of copyright is the work of authorship, which requires a work to be the product of creative expression, including literary or textual works, pictorial, graphic, and sculptural works, musical, dramatic, and choreographed works, and sound recordings. The second element of copyright is the originality requirement, which has 2 parts. First, the work must have at least a modicum of creativity, and second, it must be the independent creation of its author. Works that lack enough originality, such as titles, names, slogans, familiar symbols and designs, fonts, ingredients, or facts, cannot be copyrighted. The third element is the fixation requirement, stating that the work must be fixed under copyright law to enjoy copyright protection. This means that the work must be fixed in a tangible medium of expression. Rural argued that its directory was a collection of facts, and collections of facts can be copyrighted. They also argued the sweat of the brow doctrine, which acknowledges that facts are not copyrightable, but believes that those who have invested a great amount of time in the gathering and organizing of those facts should be rewarded. Feist argued back that while it was a collection of facts and took a great amount of time, there was zero original value about the facts collected. In 1991, the ruling was reversed by the U.S. Supreme Court in a 9-0 opinion delivered by Justice Sandra Day O'Connor, holding that the names, towns, and telephone numbers copied by Feist were not original to Rural, and therefore were not protected by the copyright in Rural's telephone directory. Their rationale was, although a compilation of facts may possess the requisite originality because the author typically chooses which facts to include, in what order to place them, and how to arrange the data so that readers may use them effectively, copyright protection extends only to those components of the work that are original to the author, not the facts themselves. A compilation is not copyrightable per se, but is copyrightable if the facts have been selected, coordinated, or arranged in such a way that the resulting work as a whole constitutes an original work of authorship. Raw data is uncopyrightable, and the way in which Rural selected, coordinated, and arranged those facts is not original in any way. Their selection of listings, subscribers' names, towns, and telephone numbers could not be more obvious and lacks any bit of creativity necessary to transform mere selection into copyrightable expression.